We are very, very happy to be here at NACM and have a chance to share the story of what one court, King County Superior Court, has been through in the last 24 plus months. As I'm sure all of you have your own experiences with the pandemic and how challenging it has been for any court professional. Something we've never seen in certainly in my career, and hopefully we'll never see again. Although I think that we took from the experience a lot of very helpful lessons and actually gained a lot in the process. That was perfect timing, Judge Rogers. So here is the former presiding judge. He held that role from 2019 through 2021. So Judge Rogers was the presiding judge of our court for that entire period of the pandemic. So he has a lot of his own war stories, and I am going to let him get settled and then have him take over.
I grew up in Bellevue, and I know the people that built this building. And it is the worst designed parking garage in the entire history of the United States of America. I never can find it. I've been here many times because there's a movie theater over here. And so I'm going to text him as soon as I leave here. And once again, abuse him as he should be abused. So first I'm going to explain a little bit about King County Superior Court. I'm Jim Rogers, presiding judge from 2019 to 2021. As many of you came into the pandemic a little unawares, had COVID twice, been shot 3 times with various vaccines. So I think I'm, those are my qualifications to talk about it. King County Superior Court is the largest general jurisdiction trial court in Washington State. We have a decentralized court system. So we have municipal and district courts. We have superior courts, which really try almost every kind of case outside of traffic tickets, minor assaults, and small claims. So we try everything. We have 4 courthouses locations, and we have 54 judges and 10 court commissioners, and about 500 total staff if you include Superior Court and the clerk's office. So we stand in a different position from some of your jurisdictions and similar to others in that we did not have a centralized court system. The way in the pandemic that played out is as follows. Our Supreme Court entered emergency orders early on in March of 2020, but really did not direct any of the innovations or any of the steps that we took. What they did was make it possible for us to experiment in a variety of jurisdictions, but the Supreme Court, again, did not direct it. They were very consultative. I spoke often with the Chief Justice of our Supreme Court as we move forward in order to get the greatest ability for us to experiment. Thanks. So all of our decisions that drove what we did happened in a 3-month time period. We're writing a report that you're going to be hearing about in this, and I actually kept a diary during the pandemic. I kept a diary from 2020 to 2021 because, as all of you well know, it's a unique event in our lifetimes, and it was interesting to see what changed. And so we went from, there's probably a similar, like the 6 stages of death and dying. There are 3 stages of complete disorganization, correct? So like all of you, there was pandemonium as our courts were shut down. We tried to figure out how to respond to that shutdown and move to emergency functions. And then we had to decide how to move forward. So I would say March was our month of scrambling. April was our month of starting to move towards what are we going to do? And May was the time when we made crucial decisions that moved us towards staying, frankly, fully open. And so how did that come about? We, and this is not in the order on those slides, but it's all on those slides. We changed our decision-making process entirely. We reorganized our administrative, partly through the exigencies needed at the time, and then realizing that it was more useful as a permanent structure. The second thing we did was, and I pushed hard for this, is I just decided, and I think others decided, or had their arms twisted, that there was no way we were going to remain closed. It was not going to happen. We had to remain open. That is our central mission. Our central mission is to serve justice, to provide access for people who need to be having their cases heard. And that's true at every level. For the litigant, there's not a pecking order of what's the most important case. For the litigant, their case is the most important. And so for us, that was our firmly held belief. But there was no way to open unless there was a public health plan that made sense. Like many jurisdictions of those of you either present or watching, our public health officers were overwhelmed. They had to deal with an unprecedented emergency. And we learned early on from them that they simply weren't going to be able to give us advice. So we got advice from two sources. The first was the Supreme Court intersected with our State Department of Health. And later on in the spring and summer of 2020, and Linda, correct me if I'm wrong here, they started giving us some information. But what really made the difference was that, and this is living in Seattle, I'll be perfectly honest, and down the street from me is an infectious disease doctor who's one of my best friends. We ski and hike. And I was venting my outrage that I couldn't get help from public health officials. And he brainstormed with me, and we cold called the School of Public Health from the University of Washington. And contacted the chair, looked at the most likely person, asked Professor Meshke if he'd be willing to work with us. He pulled in an industrial hygienist, Marty Cohen. And between the two of them, they agreed to come to our court and tour our facilities and give us advice. And their practical advice cut through some of the more hysterical, sort of notions that I think we all had about the pandemic. Could we open? Their answer was yes. You had to do certain things. There had to be far fewer people in the building. There's certain kinds of ventilation that had to occur. We walked with our facilities people with them, and they sort of said, the facility people would say, well, that seems kind of expensive. And they said, well, that's what you have to do to stay open. And we looked at them, and it was a negotiation. And they talked about the sort of Swiss cheese approach you're all familiar with, right? There are different layers that help you get to safety. Vaccinations, masking, ventilation, social distancing. All of these things, when layered upon layer, greatly reduce risk. And that's how we got to that. And that public health plan we had pretty much formulated by May of 2020. And the last was remote technology. And you're all very familiar with that. And I will just say from the perspective of King County Superior Court, and I'm sure many of you have this as well, but we were very fortunate in having people who loved remote technology far more than I'm even conversant with it, and wanted to experiment with it. And a bar, once we reached out to them, that was willing to engage. So in the May of 2020, the assistant presiding judge and I, Judge Lum, formed a task force with members of the civil and the family law and the criminal bar. And we said to them, we want to open. How do we do that? We want your input as to how to do that. And we met with, I think, maybe 50 or 55 lawyers as appropriately on Zoom and talked with them. Some of them came in person. And we asked for papers from them. We asked for memos from them. And they gave us their input. And we used that input as well to do two things. Get ideas and get the bar engaged from an early on and get the buy-in necessary for the bar to say, okay, we're not crazy about Zoom. It's not really the experience we're used to having for our clients, but maybe that's what we have to do to move forward. So the health plan, I think the watchword of all of this is MacGyver. Okay, so everything we're doing along the lines here, we're constantly improvising. We did get a lot of money to put in remote technology throughout our courthouses. That was from the Trump COVID funds. We got more money from the Biden COVID funds. But supply chain meant that we didn't actually get it all installed for a calendar year. So we were open for an entire year before we were able to do it. So we just MacGyvered the technology, and some of the health plan communication was the same way. So I told you we sought advice from UW Public Health folks. They did not have the time, because they were advising people across the country, to put together an SOP. So we wrote our own standard operating procedure for the health plan. I, the great public health authority sitting before you, wrote the PowerPoint that was the public health plan. I wrote it based on what they told me. And we did a presentation on it for criminal and civil stakeholders to explain to them what we were going to do. But ultimately, the county came through on a lot of the things that we had to do. Like a lot of your facilities, your jurisdictions, everybody left but us. The executive was gone. The council was gone. Everybody was gone except for us. We were the only people left in the building. And they seemed not to have understood that we were still there. So that was a negotiation as well, pushing them forward, saying, look, we have a constitutional mandate to provide access. We cannot close. We have to remain open. So you have to provide the facilities. You have to provide some of these things in the public health plan that we have. One of the benefits that they did, the council funded actually the Maidenbauer Center, which is close by here. It's our big convention center in Bellevue. And so we opened a brand new courthouse. And that allowed for a lot of public distancing, because we really didn't fully transition to remote technology until about November of 2020. So we were experimenting with it. We were doing our family law proceedings on it, a lot of our hearings on it. We were moving our protection orders to that. But it took a while. It was a slow move. And in the meantime, we were spacing out everyone at a large pop-up courthouse. Do you want to talk about that a little bit?
Well, sure. And the other thing that I think complicated all this, enforcing that 6-foot distance, social distancing, we had, as Judge Rogers said, the advantage of that pop-up courthouse. But in the courthouse downtown and in our regional justice center in Kent, we also had to enforce that 6-foot distancing, which required us to utilize multiple courtrooms for just one trial. So we had, jurors using one courtroom to deliberate in and another, for the actual proceeding. And so it was a logistical nightmare, as I'm sure you all have experienced as well. But the Maidenbauer Center was really, really helpful to us in giving us the additional space. And frankly, Maidenbauer didn't have conventions coming in, so it was great. It was kind of a win-win. They had some business, and we had availability of these huge conference rooms that we could space folks out. And then once we got the video technology, we were holding some virtual civil proceedings there as well. So that was great.
So the convention center became our civil courthouse. Our two traditional courthouses became our criminal courthouses. And then the family law cases were held entirely online. That's kind of how I'm leaving a lot of other kinds of proceedings out, but we moved to telephonic or Zoom for all of our other proceedings over time. So our administrative structure was traditionally, I was the presiding judge. Ms. Ridge, at the time we had a different CAO, and then she became the CAO very early on in the pandemic. So she's the head of the administration on that side. We worked together. And then we worked through our judges and executive committee and our chiefs, who are the heads of department, who have corresponding directors. Typically in the past, the CAO worked directly with the judges, and that was really how administration worked. There wasn't really a lot of other communication. The CAO would talk with the directors from time to time. At the beginning of the pandemic, I ordered a daily meeting at 8 o'clock in the morning, every day. And we met at 8 o'clock, and by about 10, we would break up into work groups. And at that meeting, any judges who wanted to come could come. Our executive committee came, our chiefs came, and all the directors came. And some people who weren't directors, who were staff members. So I would give an 8 o'clock briefing. This is what's happening today. This is what happened yesterday. And then from there, we would talk about how we're going to get to completely open. What are the groups? We responded with about 20 different subcommittees. A a lot of people weren't working very much because in March and April, we weren't really fully open yet. We didn't do that till July and August. But what happened was we started realizing over time that that daily meeting, which became a twice daily meeting, it was much more useful to have all of our directors, all of our judges together. So we essentially flattened out our hierarchy. And that meeting still exists to this day. Mm-hmm. That allowed us a much more rapid response to a variety of challenges that came up. And then over time, we just decided to adopt that as our administrative structure. So it's funny because there's debate right now in management sometimes, can we do decisions quickly enough? Or is there some need to have everyone feel like they were being heard? Does that take too much time? Does that create too much process? Our weekly meeting really is about people reporting out. It's not about necessarily making a lot of decisions. And that's very useful. Decisions are still made, I think, with a smaller number of people, but discussed with a larger number of people. So we don't get bogged down in process, I don't think, under this system.
And I think it's important to note that the executive committee, which is comprised of all of our chief judges and then some elected members, they are really the de facto policymaking body for the court. And they have a very methodical method of making decisions. So they meet twice monthly. And an item will be on the agenda first for discussion, and then at the next meeting for decision and recommendation to the full bench, which meets monthly. So then it goes to the judges, and the judges will meet the first time to discuss it, and then the next month they will meet. So it can string out over multiple months. And so, as Judge Rogers mentioned, we didn't have time, obviously, for that. We needed a more tactical group, which is what this chiefs and directors kind of subgroup served as. And we found it allowed us to be much more nimble in making those operational and logistical decisions that needed to be made to continue to operate.
Which means the executive committee became irrelevant. Yeah. And now they're doing more work again, but it's this other committee meets weekly still every Thursday at 4:00, and they make a lot of the procedural process decisions. The technology, we have an open courts constitutional rule in Washington State. What we did was we kept our courtrooms open. We basically added a screen and we just turned the screen around so you could watch the Zoom proceeding until we actually were able to install that. By November of 2020, when, as you all know, there was another shutdown, what happened then was we were sufficiently in a position to be able to move all of our civil jury trials fully on Zoom. So right now, I was a little bit late, I'm in a 4-week civil jury trial that is all on Zoom. People can come into my courtroom and they can see the Zoom proceedings, but that is how our civil proceedings, our jury trials are moving right now. And one of the big innovations we had to work on is remote voir dire. We had to do that early on because we had to depopulate the courthouse and we couldn't bring in 300 people in one courthouse and 150 people in another courthouse. We'll talk more about that throughout this. So,
do you want to talk about security? I mean, safety around the courthouse. That's another impetus.
Oh, yeah. Our downtown courthouse in Seattle, I don't know how many people are from Seattle here. During the pandemic, and there's a great book on this, actually, The Least of Us by Sam Quinones. He wrote a book called Dreamland, talking about how the fentanyl and meth, the new P2P meth, has really accelerated homelessness. And by 2020, the courthouse in Seattle looked like the set of the TV show The Walking Dead. And I'm not dismissing the horrible conditions these people are in by saying that. But there was a block by us, a City Hall Park, where there were weekly murders. There was a whole prostitution ring. There were gangs that controlled drug trade. There was a 3-year-old once found abandoned in the middle of the park. It was just unbelievable. And that was a terrible situation that's largely been solved, actually, but also meant that remote technology made a lot of sense to keep jurors from having to go buy all that. Yep. So from July 2020 to December 2021, We conducted over 1,000 remote bench trials, over 300 jury trials, 190 criminal with remote voir dire, but in-person trials. So our criminal trials were in person. All the voir dire for every criminal trial in 2020 has been, after the pandemic began, has been remote. And then 100 civil trials. And I actually think that number is a little bit low. And for all of these cases, we've conducted voir dire remotely for all of them.
Okay, I'm going to stand here because I've got some notes. I'm going to talk a little bit about a grant that we received from the State Justice Institute pretty early on in this process. So it was awarded in October of 2020. And the intent of the grant, or what SJI really wanted us to do, was to identify best practices that we had implemented during the pandemic. So we were lucky enough to get this grant, and we brought in Dr. Brenda Wagenknecht-Ivy, who many of you may know. She is the leader of Praxis out of Denver, Colorado. And Dr. Wagenknecht-Ivy was just instrumental in helping facilitate the next process that we're going to walk through, of allowing us to really document what we had done and then move forward to identify the practices that we thought were useful during the pandemic and that we might want to continue longer term. So as I said, it was awarded in October of 2020. When we obtained the grant, we felt it was just premature to start identifying what was working for us, because we were only a little over 6 months into the pandemic and we were still working at a lot of the bugs. And as Judge Rogers mentioned, we were still implementing technology in the courtrooms. But what this grant allowed us to do was just to step back and take stock of the new practices that we had implemented quickly. And during the time of emergency, we had, as all of you did, had to virtually overnight put some new practices in place to allow us to keep the doors open. So in addition to assisting with the shorter term need to determine what practices might be continued long term, we thought it would be really helpful to us to gather more information from the stakeholders and those who had experienced what we'd experimented with so far, to inform our next steps, which we're still in the process of taking, but to determine what we wanted to do longer term. So the methodology, Judge Rogers was very clear early on that we needed to make sure that we were gathering input from all judicial officers, all of our judges and commissioners, and all of the staff, not just those at the management level who had been participating in these weekly meetings, but all of the bailiffs, all of the court clerks, all of the social workers who had continued to work during this time of transformation and really contribute to the effort of documenting those new practices, and probably more importantly, identifying the lessons learned and identifying, what is working and what is not working so well, and what might we want to refine if we are planning on keeping things in place. So as Judge Rogers mentioned, the chief judges and the directors were that essential tactical decision-making group, and they help to guide and provide kind of executive oversight over this process. So what we did was, first we engaged all of the court in focus groups to document the new practices that we'd implemented. The chief judges and the directors reviewed a summary list of the new practices, and then we applied a structured decision-making process to those new practices to determine, we had pages and pages of new things that we had done in every area of the court. And we wanted to make sure that we had a clear way of identifying those few that we wanted to study further, which didn't preclude other work units from continuing on with their own experimentation. But we wanted something that would be broader and more applicable to the whole court. We wanted to focus on those practices. So the other thing we did through this methodology, and I'll talk about this a little further, we conducted surveys with the stakeholders, including the employees and the judges, the bar, and jurors and interpreters. That was fundamental to our process. And then we have been in the process of analyzing the data ever since to really get a better sense for what is our action plan moving forward. So this is a little bit about that structured decision-making process, or the guidelines we used. We really first formulated kind of a vision statement, and it was tough. I remember this so clearly that you felt like you're dancing as fast as you could to try to get things in place, and every day was presenting something new in terms of, changing CDC guidelines, or people out ill, or what's happening with vaccinations, that sort of thing. So we needed to kind of have that vision out in front of us, and so we created this guiding principle that really grounded the project team in what we wanted to do going forward. So providing access that Judge Rogers mentioned was just first and foremost a priority for us. And then we determined what selection criteria we would use in winnowing down this huge list of all the new practices that we had implemented. We wanted the ones we studied further to have broad impact. And as I mentioned, those work units that had implemented new things, like our finance department, had transitioned to a lot of electronic invoicing and payroll and those sorts of things. We didn't want to preclude that from continuing, but we did want to identify the new practices that had the broader impact, both court-wide implications, but impacted additional groups of stakeholders. And we wanted to identify those that uphold and embrace many of our core values. So equity, diversity, equity, and inclusion, accessibility, fairness, service to the public. Those were all ideals that we wanted to uphold. What were the practices that had potential long-term impacts and benefits? We wanted those things. We wanted to focus on those things that really increased efficiency, increased effectiveness, that had longer-term improvement in court performance, access, timeliness, et cetera. And then we wanted to provide an opportunity, and this was really important. Our judges and our staff were identifying anecdotally improvements, so more diverse juries, or other, the sense that we were serving more people through our facilitator's office. And we really wanted to use data to either confirm or deny that those hunches were accurate. So in the end, after applying this structured decision-making set of guidelines, we landed on 3 new innovations or promising practices that we had implemented: virtual court proceedings, and that is a broader category that also encompassed remote interpretation and electronic exhibits. Virtual jury selection was the second practice, and then remote work arrangements was third. Remote work arrangements, I'm not going to cover in this summary today, but those were really available only to the administrative staff, those who were not in court. Judicial officers and bailiffs were required to be on site, and the rest of the staff had more flexibility to engage in hybrid work arrangements primarily. As Judge Rogers mentioned, the rest of the county, the executive, the prosecuting attorney had a mandatory work from home policy that was in place until just recently. And that we never had that, but we did have some flexibility in our work arrangements. Just to summarize the data collection process we engaged in, we did survey jurors, interpreters, attorneys, and court and clerk's office employees to understand their experiences and their suggestions in the areas that we chose to study, Judicial officers, directors, managers, and supervisors were also queried through a judicial retreat where we had in person via Zoom discussions with them to solicit their ideas. And we also had department meetings where we talked about all these aspects of the process. So here's a little bit about an overview of what we did for the virtual court proceedings and interpretation. So we surveyed, and the Bar Association was super helpful in distributing surveys to their members. We ended up, it says unknown because we're not sure exactly how many they surveyed. They sent the survey to, but we received 410 responses from members of the bar. So that was super helpful to us. Then we surveyed also the court and clerk's office employees and got a good response rate there, about 65%. Judicial officers also, I mentioned, we talked with them at different meetings that we had with the judges. And then the interpreters, we also had a really great response rate of over 50%. So virtual court proceedings, we had identified specific survey categories, and each of these categories consists of a number of questions that fed into this, and participants in the surveys would rate these different dimensions on a Likert scale, 6-point scale, with either strongly agree, neutral, disagree, or strongly disagree. So these were the categories that we used for virtual court proceedings: court participant experience, ease of use, trust in the video court proceedings, their overall experience, and kind of a summary statement of whether they thought this practice should continue. And then the impact on work and employees. This was really intended to gather more information about what we also were hearing from our staff, that there was a reallocation of work associated with the implementation of virtual court proceedings. So for example, in our jury management process, our jury management staff would be the principal touch point for jurors coming in. And because we implemented virtual jury selection, we had to kind of transfer that over and have jurors summoned specifically to individual courts. So the bailiffs were taking on a lot more of the responsibility for management of the large groups of jurors than they ever had before. So we really wanted to measure what the effect of these new practices had on our employees, and thinking that would have a bearing on whether we would want to continue with these or need more resources or need to re-engineer some of the practices. Yes, please, sorry.
The virtual voir dire was probably the greatest, most chaotic change that occurred. I can't really overstate how many times we had to rework the entire system. It happened again and again. The work kept falling too hard on some people rather than others. It was just chaotic. And we're still working on it, but I think we've landed on a place where it works. So I just want to encourage anyone who wants to try something like this. It's a journey.
It's not for the faint of heart.
Yeah, it's a journey, but it's been highly successful for us. But it takes a lot of work, and we're happy to assist anyone who wants that.
And right smack dab in the middle of the pandemic, we transitioned to a new jury management information system, which was not, it was not equipped to handle virtual jury selection. So it was just add more crisis on top of the pandemic. So here's an overview of what we heard from the attorneys and the employees for virtual court proceedings. And you can see that the overall scores are pretty uniformly high with their experience. The one in the middle, their trust, particularly among attorneys, was the one that was rated the lowest. And we're still trying to ferret out what that means. Is it a comfort with the technology? Is it we heard a lot of things about, you lose something when you're not in person and have the jury before you or have the participants before you and the witnesses. It's something is sacrificed there. So that's indicative of that lower trust score. And then the impact on work and staff, that is the lowest rating for among employees. And that speaks to what I just mentioned, which was this feeling of inequity in the reallocation of work that occurred because we implemented virtual court proceedings. So overall, however, the ratings are still pretty high for those. Given my overall experience to date, I recommend that the court continue using video court proceedings for many legal matters or cases, with the understanding that the court will continue to evaluate and modify practices as needed. So employees rated that. There's a statistical significance there of a higher rating than attorneys, but attorneys still rated that pretty high. Then, as I mentioned, virtual interpreting was a part of what we surveyed folks on, and that's when we brought in the interpreters on this and really had some specific questions about video interpreting along these dimensions: court participant experience, ease of use, court assistance, the environment, impact on interpreters, trust, and the overall experience. Interpreters love this. They are just thrilled with the convenience. We have freelance interpreters who are trying to juggle their own schedules and have multiple court appearances in probably different levels of courts each and every day. The security and safety measures that, or impacts that Judge Rogers mentioned, I think factored in also to their love of appearing virtually. We have obtained interpreters in something like 170 different languages now through our Office of Interpreter Services. So some of those are dialects from very remote areas around the world. And so sometimes we have had to fly in interpreters, and remote interpretation has just helped dramatically with that, both efficiency and cost. So attorneys rated that slightly lower. I think a lot of what we heard was at first we were having challenges with the simultaneous interpretation coming through on Zoom, and it was consecutive. It's just protracting the length of proceedings, and so we're again trying to work through some of those details. So the virtual jury selection is the next area that we studied, and we had a pretty good response rate with prospective jurors. We surveyed them in August of September of 2021. The civil attorneys were the ones that we surveyed on this, and they, so that was August and September of 21, and they had to confirm that they had actually experienced virtual jury selection, and then so we got a pretty good response rate there. And then court employees we also surveyed. Again, over multiple dimensions: access, convenience, and safety, ease of use, court and staff assistance. And this is really, were there staff available or materials, instructions available to help jurors really understand how to use the technology? And how do we help our judges and staff to be able to use the technology? That came up quite a bit. The environment, do they have distractions? Timeliness and effectiveness, trust and confidence, the overall experience, and again, the impact on work and staff. Again, the jurors just overwhelmingly rated this so positively. Their experience was just really positive. I think, it probably was aided by the fact, in a perverse way, that the physical environment around the courthouse was so problematic that they were hearing it on the news, and so the idea that they could not have to come downtown was a real plus for them. Attorneys again rated that lower, and then employees rated that kind of in the middle there.
Okay, this is the last slide. The pandemic is abating, and whether you think that's a public health decision or a political decision, it really doesn't matter. We're all, across the country, people are dropping a lot of COVID restrictions. So the question then is, that I'll just say right now is, well, then what do we keep out of all this? What do we keep after the pandemic? For virtual trials and hearings, what we've decided is that I always tell people this, the future is hybrid. And what that means is we won't require virtual trials and hearings, but I think that a lot of lawyers will choose them in certain situations. They will choose to, it's much more convenient for them to get witnesses in, for example, especially in civil proceedings. And we notice in criminal cases, defense lawyers are starting to call witnesses virtually. The prosecutors aren't objecting. There's harder road to hoe with the prosecutors for some cases, but because of the confrontation issues. So the future is hybrid for that. Voir dire, we are trying to keep as a business practice. We need new court rules to do that through our Supreme Court, and we're fighting that battle right now. We're lobbying with our Supreme Court. They need to approve those rules. I think that our Chief Justice and others they see that the future is through technology. A lot of people don't have that technology yet, but we were surprised to learn when we looked this up during the pandemic. So the Pew Research Institute, more people own cell phones than own cars or televisions. 96% of Americans have a cell phone or access to a cell phone. So this whole pandemic, we've allowed people to come in person for voir dire if they wanted to. And there's always been a couple for many trials that would come in, 3 to 6 to 10, and they'd be questioned in person. But for my last trial, there was nobody. And so it's virtually, no pun intended, virtual. So, and come to find out, we have solved a problem that the court has had over, well, several millennia. So we all have the problem that you bring in a certain number of people in your courtroom or courthouse, and that's the number of people you have for that jury call, right? So we have 300 in Seattle, 150 in Kent. So trials are always waiting for jurors. We summon 1,000 a week. We never, and I mean never, run out of jurors. None of our trials are delayed anymore waiting for jurors. The civil cases don't have to worry about all the criminal cases taking all the jurors. That problem is completely solved. And we didn't even try and solve for that. That was just a benefit that came out of all of this. We do need to keep voir dire virtual for both civil and criminal cases. It's just too expensive to do both models. So we frankly made it the hard choice for the Supreme Court. We hope they'll approve it. We've told them this is not a one-off. This is a business practice. We need it to be adopted up or down, or we'll have to go back to in-person voir dire. Our administrative structure has become much better in the sense that we've shared more information. We can move much more quickly from a process perspective. And lastly, I'll just say that we have a big problem that we now face. So we have all of these people who've had all these new practices, and some of them are at the finish line, and some of them are about 2 steps out of the starting blocks. It's a huge problem with training, huge. So people will come into our court houses, and they'll have judges that are just trying the cases lickety-split, and then they'll have some people, the cases are taking far longer to pick a jury, to get going on Zoom. Most people are sort of in the middle, but it's a problem. So that's a lot of the money we requested in the Biden package of COVID funding was to deal with our training. But that is a long-term challenge for King County Superior Court to institutionalize our practice, to make them efficient and effective for the litigants. And so to sort of wrap up, I'll just say what led to all of this, the determination to remain open. Fortunately, we had healthcare experts that were able to give us a health plan to stay open, and the determination to MacGyver all these solutions, to realize that, you know, it was going to be a train wreck for a while, but we just had to keep trying. And then by the fall of 2020, we were on our way, but it took a lot of work, thousands of meetings, and we made it through there. So I think that's our presentation, unless you have any.
No, the only thing that I'll say in addition is we had to coalesce as a court, and through these frequent meetings, and Judge Rogers, I think, created some 30 different ad hoc committees that were dealing with specific slices of the operations, but it, in a way, it further kind of bonded the court and the judges. The relationship between the judges and the management has strengthened, I think, because there is more of an understanding of this interoperability and need for information on both ends in order to make a solution work. We had spent so long, so many efforts creating a continuity of operations plan through the years that has basically sat on the shelf. I mean, it's a good plan, but when push comes to shove and you're faced with these decisions you need to make virtually overnight, it took that in-person communication, constant communication to actually make it work, and really dedicated judicial officers and staff. We could not have done it unless the entire court pulled together. So, what I would say.